My honorable colleagues, my name is Honorable Garba Datti Mohammed. I represent Sabangari Federal Constituency of Kaduna State. I move for a bill for an act to alter Section 12, subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999, Chapter C23, to include the prohibition of provisions contained in treaties to be domesticated that are in conflict with the moral and family value system of Nigerian state, and to deem such provisions as void wherever they appear in any treaty to be adopted for domestication. I move.
Honorable Ayuba, second.
Thank you once again, Mr. Speaker. I will lead this debate by quoting from Section 12 of Section 1 of the Nigerian Constitution, as amended. The provision says, no treaty between the Federation and any other country shall have the force of law to the extent to which such treaty has been enacted into law by the National Assembly. Mr. Speaker, the purpose of this provision is to empower the National Assembly to domesticate international treaties. But however, Mr. Speaker, we are in an era in which treaties and other instruments contain some morally alien and ambiguous nature. We have treaties such as the Beijing Platform of Action, which has formulated different concepts. For instance, unlimited right of abortion, right to determine one's sexuality, whether you want to be a heterosexual, homosexual, transsexual, and so on and so forth. So this type of ills, Mr. Speaker, are taking hold in international relations. Only recently, Mr. Speaker, just as early as January this year, according to the Daily Mail of London, which says forms were officially circulated to 13-year-old children to fill, to select from 25 different options of their sexuality or gender. This is based on the belief that everybody has his own right to determine his own gender. For instance, Mr. Speaker, apart from the three I earlier mentioned, that is homosexual, heterosexual, transsexual, we have other options of gender descriptions that include such things as gender fluid, demigirl, trigender, non-binary, genderqueer, multigender, transgender, bigender, neutrals, and so on and so forth. So this is official survey conducted in the United Kingdom to give people the right to choose their own gender. So this type of invasions and ills are now becoming very rampant, and at times they tend to be sneaked into international treaties. So the proposed alteration, Mr. Speaker, seeks to add that provided that the National Assembly shall not enact into law articles or provisions or of a moral content in a treaty that tend to contradict or compromise the moral or family values of Nigerian state, and any article or provision of such description in an enactment made pursuant to this section shall be deemed not to have been enacted into law by the National Assembly. Mr. Speaker, we know before any international domestication, it has to come through the National Assembly. But as a way of an auxiliary precaution and to make us perpetually vigilant on such ills, that's why we deem it necessary that this amendment should be taken into consideration. The main objective of this amendment, Mr. Speaker, is to isolate the Nigerian state from immoral practices that are fast taking hold on the world and consequently preserve from moral decay. What are the justifications of this bill, of this proposed alteration? Mr. Speaker, if you could collect, in this National Assembly, Same-Sex Marriage Prohibition Act was enacted to address such new immoralities. But in the context of this alteration, you'll find out that this provision of Same-Sex Marriage Prohibition Act is very narrow and inadequate in three respects. One, it is restricted to same-sex relations and does not contemplate other immoral possibilities. Two, it does not appear to have contemplated the alien gender scope that we just illustrated. And third, and three, the same-sex prohibition legislation is just a local criminal legislation that, given the decision of Supreme Court in the case of Abacha versus Fine With Me, will just be considered as an inferior legislation when you look at the legal hierarchy of Nigerian legal system. So, with the kind permission of Mr. Speaker, let me just read part of this judgment so that we'll have a better grasp of what we're trying to achieve. Before its enactment into law by the National Assembly, an international treaty has no such force of law as to make its provision justifiable in our courts. Where, however, the treaty is enacted into law by the National Assembly, as was the case with the African Charter, which is incorporated into a municipal, that is domestic law, by the African Charter of Human Rights and People's Rights Ratification Enforcement Act, Cap 10, Laws of the Federation of Nigeria, 1990. It becomes binding to our courts, must give effect to it. All other laws falling within the judicial power of the courts. By Cap 10, the African Charter is now part of the laws of Nigeria, and like all other laws and courts must uphold it. No doubt, Cap 10 is a statute with international flavor. Being so, therefore, I would think that if there is a conflict between it and another status, its provision will prevail over those of other status, for the reason that it is presumed that the legislature does not intend to breach an international obligation. To this extent, I agree with the lordship of the courts below that the Charter possesses a greater vigor and strength than any other domestic status. So this is the situation, because any other legislation, our status here is inferior to any status that has international flavor and has been domesticated. There is an instance in the last amendment, Mr. Speaker, of the Constitution of this country. If you look at section 254C, subsection 2 of the Constitution of the Federal Republic, 10th Alteration Act 2010, which gives the industrial court certain powers in respect of application in any international convention, treaty, or protocol in issues of labor and employment. So, whether rightly or wrongly, this has been construed to mean that they now have powers on international issues that don't need the domestication of Nigerian parliament. So, is such sneaking or such provisions that we are afraid that they can be sneaked into international treaties. Mr. Speaker, this is not the first time in our legislation that will have something of this nature. If you look at the repugnance decree, a doctrine, that is a doctrine that was introduced by colonial masters and is still being retained in our own laws. that any indigenous customary law which is repugnant to natural justice, equity, and good conscience, or against public policy is not to be applied by Nigerian courts. So, with this implication, it has become paramount to include this auxiliary precaution so that we can be perpetually vigilant so that such ills cannot sneak into our destiny. And this amendment is in line with our own constitution. If you look at section 17, subsection 3F and H, section 21 and section 23, these are sections that specifically try to preserve the family value and the family value of a moral value of Nigerian state. So, Mr. Speaker, I urge that this amendment should be considered when it reaches the Committee on Constitutional Amendment. Thank you, Mr. Speaker.
Minority